The National Labor Relations Act, enacted in 1935, guarantees certain rights to employees in the United States concerning their ability to organize unions, engage in collective bargaining, and participate in other concerted activities for their mutual aid and protection. These rights are crucial in promoting fair labor practices and protecting employees from unfair treatment by employers. Here are the key employee rights under the NLRA. 1. The right to form, join, or assist labor organizations, as outlined in Section 7. Employees have the right to form, join, or assist labor organizations, also known as unions, for collective bargaining purposes. They can bargain collectively through representatives of their own choosing and engage in other concerted activities for mutual aid or protection. This means employees can join or form unions to negotiate with employers regarding wages, hours, and other terms and conditions of employment. They can also engage in activities such as strikes, picketing, and other forms of collective action to improve working conditions or address grievances. Number 2, protection from interference, restraint, or coercion, as specified in Section 8. Employers are prohibited from interfering with, restraining, or coercing employees in the exercise of their rights under Section 7. They cannot dominate or interfere with the formation or administration of any labor organization. Discriminating in regard to hiring, tenure, or any term or condition of employment to encourage or discourage membership in a labor organization is also prohibited. Employers cannot retaliate against employees for engaging in union activities or other concerted activities protected by the NLRA. This includes threats of reprisal, actual reprisals, surveillance of union activities, and discriminatory actions. Right to refrain from union activities, as outlined in Section 7. Employees also have the right to refrain from joining or assisting a labor organization. They can choose not to participate in union activities, including strikes or picketing, unless they are involved in a lawful strike. Employees who decide not to join or support a union cannot be discriminated against or subjected to adverse employment actions based on their decision. Right to information, as stated in Section 8, subsection A.5. During collective bargaining, employers are required to bargain in good faith with the representatives chosen by employees. This includes providing relevant information that is necessary for the union to effectively bargain on behalf of employees. The right to fair representation is a cornerstone of union responsibility. Unions have a duty to represent all employees in the bargaining unit fairly, regardless of union membership status. They must avoid arbitrary or discriminatory actions in handling grievances and other matters affecting employees. Enforcement and remedies under the NLRA are critical to maintaining fair labor practices. The NLRA is enforced primarily by the National Labor Relations Board, or NLRB, which investigates and adjudicates unfair labor practice charges filed by employees, unions, or employers. Remedies for violations of employee rights under the NLRA may include reinstatement of terminated employees, back pay, posting of notices to employees about their rights, and other corrective actions to restore the status quo ante. Recent developments and challenges have shaped the landscape of labor rights. In recent years, there have been debates and legal challenges over the scope and application of employee rights under the NLRA, particularly in relation to new forms of employment, such as gig economy workers, and the use of technology in organizing efforts. The composition of the NLRB and judicial interpretations also influence how these rights are enforced and protected in practice. Overall, the NLRA provides a framework for balancing the interests of employees, employers, and unions in the United States, aiming to promote stable labor relations and protect fundamental rights in the workplace.